Um, before the short adjournment, we were finding it a little bit hard to hear you, especially if there was noise outside. So please, could you keep your voice up for us?
Oh, I'm very sorry, my lady.
Thank you. I don't know why, but you wouldn't have thought we lived in a particularly noisy environment, but we do.
I'll bear that in mind. Before the short adjournment, I had taken the court to the example where A gives money to B and then borrows that money back from A, which is, in broad terms, the mischief Section 103 is aimed at. We now have to look at how Section 103 deals with that. Section 103 is at page 53 of the Authorities bundle. And starting with subsection 1, it provides, subject to subsection 2 below, if in determining the value of a person's estate immediately before his death, account would be taken, apart from this subsection, of a liability consisting of a debt incurred by him, that's A in the example, that liability shall be subject to abatement to an extent proportionate to the value of any of the consideration given for the debt, i.e. the consideration given by B in the example, the money lent back, which consisted of A, property derived from the deceased. And just pausing there because we're on lim A for the moment, we then have to ask, what does property derived from A mean? And you are told that in subsection 3, which says, in subsections 1 and 2 above, property derived from the deceased means, subject to subsection 4 below, any property which was the subject matter of a disposition made by the deceased, either by himself alone or in concert or by arrangement with any other person, or which represented any of the subject matter of such a disposition, whether directly or indirectly, and whether by virtue of one or more intermediate dispositions. So you have to look at the consideration given by B for the debt incurred by A and ask, was that consideration or did it represent property which was the subject matter of a disposition made by A? And in the case of the example, the answer is yes, because A made a disposition of the money to B, and that property was the property B gave as consideration for the debt incurred by A. So that's how lim A works in broad terms. If that was all that section 103 provided, then my learned friend Mr. Davies' fear that it would be easy to avoid would indeed be realised. Because, to take an obvious example, what if B lends 100 to A first, and then later A gives 100 to B? In that case, it's no longer the case that the property given as consideration by B for the debt incurred by A was or represented the subject matter of a disposition made by A.
But in the reverse example, it may well be that the giving of the property back, so to speak, has discharged the debt.
Well, I suppose that in that case there isn't a liability at all.
So
you
yes.
wouldn't get into section 103. But that's just assuming it was on the face of it a separate gift. and not by way of repayment of the debt. That's just a very simple example
How you might
of
get
how
around it.
one might avoid the operation of lim A. And so that is where lim B comes in. If we go back to section 103, subsection 1, it's the value of the consideration which consisted of A, or B, consideration, brackets not being property derived from the deceased, given by any person who was at any time entitled to, or amongst whose resources there was at any time included, any property derived from the deceased. So A looks at the property given as consideration for the debt and asks effectively, is it traceable back into property previously given away by A? B looks at the person who gave the consideration and said, was that person, B, someone who at any time had any property derived from A? But then lim B is subject to a kind of safeguard in subsection 2. And what subsection 2 is doing is two things, really. First of all, it is saying that if the amount or value of the consideration given by B exceeded the total amount of property derived from A, so for example, if B has lent 200 to A, but the most that A has ever, during his lifetime, given to B is 100, you only abate the debt by 50%. That's the first thing it's doing. The second thing it's doing is to say that for these purposes, you don't count any property derived from A where the gift or other disposition of that property by A was not made with reference to or with a view to enabling or facilitating the giving of the consideration or the recoupment in any manner of the cost thereof. In other words, if you find a gift from A to B at some later point, or at any point, but it's shown by the taxpayer that actually that gift had nothing to do with the debt, then again, you don't count it. So one sees, hopefully, in terms of the overall structure of section 103, that lim A is, if you like, the base case. And it's lim B which spreads the net much wider to catch consideration which is not directly traceable back into something given away by A, but subject to the safeguards in subsection 2. Now, in this case, the revenue have only ever relied on lim A. My learned friend Mr. Davey confirmed that expressly yesterday, and I do ask the court to note that because there is a footnote in his skeleton argument which says, oh, well, if it's not A, maybe it's B, without giving any reasons. But that, so I asked the court to note that he has now expressly said it's just A. And that is relevant because the essential criticism the revenue make of the Upper Tribunal's decision is oh, you've given far too narrow a construction to section 103. Why on earth should it all depend on whether the whether the disposition of the property derived from the deceased happens before or after the incurring of the debt? To which the answer is, the Upper Tribunal has given what you could call a relatively narrow construction to the narrow limb of the provision. But the revenue are not relying on the wider limb.
That all rather depends, doesn't it, on whether the narrower view requires that the consideration consisting of property derived from the deceased has to move from that person, the deceased, before the debt is incurred, rather than afterwards.
Yes, of course, my lady. So I have to.
And I'm not sure that can be right, because shouldn't one give this section a purposive construction and simply ask whether, as part of this transaction, property derived from the deceased is in fact and reality the consideration for the debt?
Yes, my lady. So in other words, I now have to explain why the Upper Tribunal's construction was correct. What you are asking under lim A is you identify the consideration given by B for a debt incurred by A. And then you say, was that consideration property which was or represented the subject matter of a disposition made by A? And the dispute between the parties is really about the temporal standpoint from which one asks that question. My submission is that when you are asking that question, you have to ask, was it property derived from the deceased in the hands of B at the time B gave the consideration? And the reason is, well, partly the reason is, I say, when you read subsection 3 into 103.1a, the more natural reading is that it's talking about a time in the past.
Because it was.
Well, there's a number of wases in there. Everything's happened in the past, but you're saying there is a debt incurred by A. Then you say, what was the consideration for that debt? Was that consideration property which was the subject matter of a disposition made by A? Now, the revenue say, well, it doesn't say that. Why can't you just look back from the time of death and say that consideration, was it property that was the subject matter of a disposition made by the deceased at any time? Who cares whether it was before or after? And the reason that must be wrong is because it makes lim A far too broad. So take, for example, a situation in which A borrows 100 from bank and then gives that 100 to her child, C. On the revenues analysis of the wording, you say, let's look at that 100 given as consideration by bank for the incurring of the debt by A. And then ask, looking back from death, was that 100 property which at any time was the subject matter of a disposition made by A? To which the answer would be yes. Because A took that 100 and gave it to C. And so on the revenues analysis, it would appear that to the extent that 100 is still outstanding on A's death, it can't be taken into account because of section 103. And that in my submission must be wrong.
Isn't the difficulty with that the introduction of C into the equation? Because given the examples, it really deals with a transaction that's going backwards and forwards between the same two people. And so the revenues position is that where you've got consideration which is being given, if you like, for the debt, you have to be looking at both sides of that transaction, the debt transaction, and not at whether the deceased has handed the money over to some third party.
That's, I suppose that's right, my lady. But I may be missing your ladyship's point, but the point I'm making is, in the example of A borrowing from bank and giving the 100 to C, I don't understand how, on the revenues case, section 103 doesn't abate that liability.
Well, because it's not because the giving the money to C is not consideration for the debt.
No, it's not. But the consideration for the debt is the 100 lent by bank to A.
Yes.
Then you have to ask, was that 100 property which was the subject matter of a disposition by A? And on the revenues case, the answer is yes.
And it doesn't matter at C, there was a disposition.
It doesn't matter if it's C or anyone else. It doesn't have to be to B.
Well, I'm not sure.
And that's why you're saying it's 2-1.
Yes.
Sorry, I'm being very slow. Determining the value of a person's estate. A liability consisting of a debt. So we're not dealing with dispositions. A debt incurred by him. In this example, a debt incurred by him to the bank, right, for borrowing £100. Then liability should be subject to abatement to an extent proportionate to the value of any of the consideration given for the debt which consisted of property derived from the deceased. So why has the fact that the dead person has handed that £100 over to a third party got anything to do with that part of the statute?
Because property derived from the deceased, my lady, is defined in subsection 3 as property which was the subject matter of a disposition by the deceased, etc., etc.
Ah. So any disposition?
Yes.
I see.
Which is why you say that
Right.
construction makes A too wide.
That's my submission, my lady, yes.
So you would say that a disposition made by the deceased can't be given a narrow construction of a disposition made to the party who is the other party to the transaction, where you're looking at consideration.
No, that is clear.
Yes. Very odd. Yes, okay. Sorry, I'm catching up. It's subsection 3. Yeah.
So finally, just to relate that to the actual facts of this case, we have a debt which, at this point in the argument, we are accepting, contrary to my submissions earlier, was deemed to have been incurred by Mrs Elborne. That is the liability under the note. We then say, what was the consideration for that debt? It was the property. In the hands of Mrs Elborne, playing the role of B, as it were, was that property, i.e. the house, property which was the subject matter of a disposition made by Mrs Elborne? And the answer is no, because you have to ask, was it property derived from the deceased in the hands of B at the time B gave the consideration for the debt? So in Mrs Elborne's hands at the time of the sale contract, she had the house, but it wasn't property, from her perspective at that time, it wasn't property which was the subject matter of a disposition made by herself. Or to perhaps put it a little more intuitively, it wasn't property derived from the deceased, it was just the deceased's property.
Doesn't derived from simply mean that the deceased is the source of the property?
It suggests
something which belongs to the deceased or emanates from the deceased.
Well, emanates, I would agree with, my lady. But if I this is my pen. Is it property derived from myself? No, it's just my property. The expression property derived from someone implies that it has already come away from that person and then gone to someone else.
Not merely that they're the source of it.
Well, it's a defined term anyway, my lady.
Mm. And what's the definition?
In 3, property which was the subject matter of a disposition.
So it's got to be the subject matter of a disposition, and you say it's not the subject matter of a disposition at the time of the sale?
Yes. In
Just
Mrs.
her pen.
Elborne's hands, playing the role of B, you couldn't say of the
You
house.
couldn't say she sold it to herself.
I think you have to say she sold it to herself if I've lost on the debt incurred by point. But even proceeding on the basis that she is selling something to herself, can you say of that something that she is selling that it is property which was the subject matter of a disposition made by herself?
And you'd say that that's using the sale twice.
Yes.
Sort of double
Double count.
Double demon.
I mean, that's the other. I don't know. That's the other. I suppose that's another, maybe more intuitive way of putting it. The same transaction is doing double time.
Mm.
That is, I think, all I have to say about section 103. So unless there's anything else that I can assist with on that point, I'm going to move on to Ramsey.
Really, just a comment, really. I think when you introduced this part of your submissions before the adjournment, you said this was a difficult question. Indeed, I think you said it was the most difficult part of the case. And obviously,
Yes.
we'll have to form our own judgment on that. in due course. But the fact you acknowledge it is a difficult point, perhaps just reflects the sort of intuitive feeling that when you're looking at language like property, which was the subject matter of a disposition made by the deceased, the temptation is to answer, but of course the whole thing was about a disposition made by her, namely of the property in the first place. This is what the whole scheme was sort of premised on, but doing it in such a way that she ended up still able to go on living there. And the answer to that may be, if you're right, the kind of intuitive double deeming, or it's just being her property in a sort of basic sense, which doesn't admit of any elaboration.
Yes, but I think the fact that it's difficult it doesn't particularly tell in favour of one party.
No, it doesn't, unless perhaps one solution is much easier than the other, and one begins to wonder what's wrong with it. Whereas,
but I suppose that the broad point I'd make is, on any view, section, and I suppose this is where the point about it being difficult goes. Section 103 is not a provision that anybody could rationally describe as open-textured, broad brush. It's intricate. It's designed to require intricate scrutiny of what, on the face of it, are real historical transactions. And so I'd say don't be surprised if this is anyone's intuitive starting point. If the intuitive starting point is, well, it's got something to do with artificial liabilities, this looks a bit like an artificial liability, surely it must apply. Don't be surprised, is what I'm saying, if that starting point is not the end point.
and the fact it's a section which on the face of it seems to be very little used, or at least little litigated, may perhaps just reflect the fact it's rather curious and complicated put together. And the more you look at it, in a sense, the more baffling it becomes.
Yes.
Anyway, you've offered us a sort of guide through the labyrinth, so thank you for that. We will have to make the best of it we can.
Thank you, Mother. So I'll now move on to Ramsey. The Revenue's case under this ground is really built on the decision of the Supreme Court in Rossendale. Rossendale was a case which concerned transactions which had no substantive real-world effects and whose only purpose was to achieve a result clearly at odds with what the Supreme Court identified as the overall purpose of the statute in question. The problem with the revenue submission, the overarching problem with the revenue submissions under this ground, is that they try to carry over a Rossendale-type analysis into this case, where the facts, and critically the statutory context, are very different. In that regard, before I get into the detail, I would like, if I may, to make a few general points. And to the extent that the court is interested in submissions about the wood and the trees, or the undergrowth and the sky, or whatever metaphor it was that my learned friend employed, then what I am about to say can double as my submissions on that theme. So first point, there is no doubt that as an integral part of the arrangements, or scheme if you like, Mrs Elborne made a real gift of a real asset, the note, which had a real and substantial market value. And there is no doubt that that gift would have been chargeable to inheritance tax had she died within 7 years. It wasn't chargeable because she survived 7 years. That's how inheritance tax works, I'm afraid. The next point is, if one asks at a very high level, which probably isn't the appropriate level, but if one does ask, what is it about what was done here that is at odds with the general purpose of the inheritance tax legislation? It's true that Mrs Elborne was aiming to reduce the value of her estate on death, but the mechanism by which she did so was to make a potentially exempt transfer. You're allowed to do that. Now, presumably my learned friends don't have a problem with people making potentially exempt transfers, but what they say in the first paragraph of their written submissions and repeatedly thereafter is this is all terribly wrong because Mrs Elborne tried to give away an asset that represented most of the value of her house while continuing to live there. Well, that, I'm afraid, was precisely the aim of the transactions in most of the leading inheritance tax cases decided this century. I'm thinking in particular of Ingram, Eversden, Bisoni, and Hood, which we will, of course, look at in more detail in due course.
Sorry, which was the second one on that list?
Eversden, my lord.
Eversden, thank you.
And in none of those cases did the court approach the issue by some kind of broad brush appeal to the general purpose of the Inheritance Tax Act. The taxpayers in those cases may or may not have been successful in avoiding the application of the gift with reservation provisions. And if, as in Hood, they were unsuccessful, despite having done exactly the same scheme that the taxpayers succeeded on in a decision of the Court of Appeal a few years earlier in Bisoni, if they were unsuccessful for what might at first glance seem a highly technical reason, then too bad for them. But that is a function of the application of the gift with reservation provisions according to their terms, not a function of the overall purpose or spirit of the Act, or asking questions like, was their beneficial interest substantially affected, or whatever the question.
That's why I asked Mr. Davey the question, which particular provisions of the Act, of the statute, was he saying ought to be given a practical or more generous interpretation in consequence of the application of Ramsey and Rossendale? Because, as I understood it, if you don't get home under Section 103, one then still has to find a provision of the statute to which to attach the Ramsey-Rossendale approach, which, on my understanding, is you look at the substance of the reality of the transaction, however it's dealt with legally, yeah, and you say to yourself, does it fall foul of this provision or doesn't it?
Yes, quite, my lady. And indeed, as somebody who's repeatedly complained throughout this litigation that I don't understand which provisions the revenue purport to be construing, I listened to my learned friend's answer to the question, and I will, of course, come on to deal with the provisions he identified. the
49.1 and 5.3, I think, was the eventual answer.
That's right.
I got. Yes.
as explained at paragraph 39 of his skeleton, which
Yes.
we will look at. But I'm still on my wood and the trees point,
Yes.
to the extent it's relevant.
Cutting through the foliage, yes.
And the point ultimately, to adopt an observation made by my Lady Justice Andrews at approximately 10:35 yesterday morning, either it works or it doesn't. There is nothing more to this case than that. Either it works or it doesn't. And the third point, general point I wanted to make, is that the traditional formulation of the Ramsey principle, which is to say that a purposive construction of the statute may sometimes require the court to disregard artificial steps in a composite transaction which have been inserted for no business or commercial purpose other than tax avoidance, is on the face of it very difficult to apply to inheritance tax. First of all, because inheritance tax, pretty much by definition, is not concerned with business or commercial transactions. Secondly, because it is an integral part of the scheme of the legislation that you are permitted, indeed encouraged, to avoid the liability that would otherwise arise on your death by means of inter vivos gifts, so long, of course, as you survive 7 years. The only judicial commentary on this issue, i.e. how do we apply this traditional conception of the Ramsey principle to inheritance tax, at least the only one that I'm aware of, is in the judgment of Lord Justice Millett in England, and it's to that I would now like to turn. This the Court of Appeal's decision in Ingram is tab 26 of the authorities bundle. And I don't think we've actually been to Ingram yet, so I'd better explain what the facts were, and in particular how the Ramsey issue arose. Lady Ingram was the freehold owner of the house in which she lived. She conveyed the freehold of the house to a nominee for herself. That was day one. On day two, her nominee granted her a lease over the property, and on day three, the nominee, at Lady Ingram's direction, conveyed the freehold reversion to trustees for her children and grandchildren. And the revenue had three arguments. The first argument was that the grant of the lease by the nominee was invalid on the basis that you can't grant a lease to yourself, and that the grant of a lease by your nominee to you is the same thing as a grant of a lease to yourself. So that was the first argument. If the grant of the lease was invalid, it would follow that Lady Ingram remained the beneficial owner of the whole property up until the point at which the freehold was transferred to trustees. At that point, the trustees came under an obligation, either at law or in equity, to grant the lease back to Lady Ingram. In other words, on the basis that the grant of the lease by the nominee was invalid, the legal effect of the transactions were a gift and lease back, a gift to the trustees subject to a lease back to Lady Ingram, and that was said to be a gift with reservation. The way the Ramsey argument came in was that the Revenue said, if, contrary to their primary submission, the leases were valid, that the lease granted by the nominee was valid, and if the validity of that lease made all the difference to whether there was a gift with reservation or not, then under the Ramsey principle, the court was invited to ignore the grant of the lease by the nominee as an artificial step inserted for no purpose other than tax avoidance, so that even if the grant of the lease was valid, the overall transaction should be analysed for tax purposes as if it wasn't, and as if there was simply a gift and lease back. Now, in the event, all of the judges from the High Court upwards either held that the lease was invalid or that it was, that was Mr. Justice Ferris in the High Court and Lord Justices Nurse and Evans in the Court of Appeal, or they held that the lease was valid, but that there would have been no gift with reservation even if it hadn't been valid. That was Lord Justice Millett in the Court of Appeal and all of the members of the House of Lords. So in the event, based on their respective answers to questions 1 and 2, nobody actually had to consider the Ramsey argument. But Lord Justice Millett did anyway, and I submit that what he said deserves careful consideration, not only because it's the only judicial commentary on this topic, but also because Lord Millett himself was, of course, counsel for the Crown in Ramsey, and therefore, to some extent, the person responsible for introducing this way of thinking, perhaps derived from the American authorities, into English jurisprudence. So, what did Lord Millett make of this? The relevant passage is at page 397 of the authorities bundle. And at the top of the page, there is a quote from McGuckian. And we can then start from the second sentence of the paragraph below that quote. It is, of course, beyond dispute that Lady Ingram was tax motivated. If inheritance tax had not existed, she would not have attempted to make a potentially exempt transfer of her property. But this is not sufficient to disregard the transaction or any steps in it, or it would not be possible to make a potentially exempt transfer at all. What is required to enable the court to disregard a transaction or step in a transaction is not the presence of a tax avoidance motive, but the absence of any other purpose. This is often described as the absence of any business purpose, but in this context, business purpose does not mean commercial purpose, but simply non-fiscal purpose. The circular and self-cancelling scheme in Ramsey and the artificial splitting of the disposal into two in Furness and Dawson had no purpose at all except the avoidance of tax. See Ramsey per Lord Wilberforce describing transactions designed only to avoid tax and lacking otherwise in economic or commercial reality, and citing the United States authorities. In the present case, Lady Ingram set out to make a genuine gift of a reversionary interest in her property to her children. Although motivated by a desire to save tax, this was a non-fiscal purpose. The transaction was not a mere paper transaction and cannot simply be disregarded for tax purposes like the scheme in Ramsey. Nor were any of the steps artificially inserted into the transaction for an exclusively fiscal purpose. The structure of the transaction, which is what makes the scheme appear artificial, was not, as in Furness and Dawson, tax motivated. The several steps by which the transaction was effected were an integral part of the proper and appropriate conveyancing method to achieve the gift of the freehold reversion which Lady Ingram intended to make. They were necessitated by the conveyancing problem inherent in the need to separate the two interests in land so that Lady Ingram could deal with only one of them. Had she been entitled to a fund of money, a single step would have been sufficient. In my judgment, there is no justification for disregarding any of the steps in the transaction. The point, really, is that, of course, the conveyance of the freehold to the nominee and the taking back of a lease from the nominee, of course, that looks artificial. But the point of those transactions is to separate a single illiquid asset into something that Lady Ingram can give away and something she can keep. And that, according to Lord Justice Millett, as he then was, is a non-fiscal purpose. And in my submission, the facts in this case are analogous. Of course, there's something a bit artificial on the face of it in Mrs Elborne selling her property to trustees for herself in exchange for the loan note. But the purpose of those transactions is to put in her hands something she can give away, the note, and something she can keep, her life interest in the property.
If you look at the conclusion to Lord Millett's judgment, actually, it makes the point for you. Lady Ingram made no attempt to avoid tax by pretending to make a gift whilst retaining the subject matter of the gift.
Yes.
Mrs Elborne made no attempt to avoid tax by pretending to hand over her property to the trustees while retaining its subject matter. Lady Ingram attempted to retain a present interest in land and make a gift only of that which she did not retain. Mrs Elborne retained a beneficial interest which exposed her to, potentially, to IHT.
Yes.
And she also made a PET, which potentially exposed her to IHT, but she survived the 7 years.
Yes. And of course, there'll be more to say about this when we come on to the actual gift with reservation issues. But for the moment, the point I'm making is that within the traditional formulation of the Ramsey principle, entering into transactions to split up an asset you have into something you can give away and something you can keep does not count as an artificial step inserted for no purpose other than tax avoidance.
Yeah.
And that leads into Lord Hoffman's comments about, in effect, breaking up the cake into slices. You can eat a slice, but that doesn't.
Yes.
Taking advantage of the sophistication of English land law for
Yes.
that purpose, which again is something which Mrs Elborne was doing here, taking advantage of the trust structure which enabled her to end up with a life interest, gave her the right to reside on the one hand, and also providing the monetary debt, which was the subject of the PET, which would have been chargeable had she not survived the full 7 years.
Yes, ma'am.
So what's wrong with that?
Well, suppose that's a submission I'm making, really. As a matter of the highest authority, what's wrong with this? Nothing. We then have to go on and apply section 103, 102, etc. As my lady said, it works or it doesn't.
But I mean, there's a big problem in this whole area, at least this is to me, because I thought that was the case. We looked at the legal transactions which are taking place. On any view, possession of the relevant property passed under a lease which was found, as a matter of fact, not to be sham, but yet it was disregarded by the Supreme Court. Reasons which I still sometimes find a little confusing.
Yes. Well, don't tell Lord Briggs or Lord Legate, my lord, but I of course am with you. But I think for today's purposes, all I need to say is Rossendale is a totally different type of case in a totally different statutory context.
But it seems, yes, I want to hope if one is able to distinguish it, it might be for a slightly better reason. I'm not saying it's a bad reason, just different. Distinguishing it on the facts might again seem like a slightly easy way out, given that the impression one gets from the Supreme Court's decision in Rossendale is it was, I'm not saying it's necessarily wrong, but it was a very merits-driven approach to what was on any view a very disreputable scheme, because it involved misusing statutory procedures and relying on official, what's the word, I won't say lackadaisical, but a rather relaxed approach to enforcement of regulations which were designed, which, if properly enforced, would have put an end to the scheme in the first place. And it also involved the Supreme Court divining the purpose of the relevant rating legislation in a way which was perhaps not immediately self-evident.
Yes. Well, I suppose one thing that is absolutely clear from the Supreme Court's decision in Rossendale, whatever one might say about the result, is that the Ramsey principle is nothing more and nothing less than the application of ordinary principles of statutory interpretation.
I mean, that's why we were pressing Revenue's Counsel to explain exactly what was being construed in this particular instance.
And so I now have to turn to the provisions we're construing.
Yeah.
My learned friend said the answer is to be found in paragraphs 39.1, 39.2 of his skeleton argument. Uh, 39.1 deals with section 49. So what is said here about the construction of section 49? HMRC submit that the UT erred in law in holding that the language and statutory context of section 49.1 did not support HMRC's submission. As noted earlier, section 49.1 does not address liabilities expressly at all. Well, I think we all agree with that. It is therefore difficult to see how the language or context of the provision can indicate that liabilities that were solely incurred for the purposes of reducing the value of property deemed to be in the life tenant's estate should be treated as deductions in valuing that estate. Brackets, well, I'm not sure what the words in brackets add actually, but so the point that seems to be being made is Section 49 on its face doesn't authorise a deduction for liabilities at all. A fortiori, it doesn't authorise a deduction for liabilities incurred for no commercial purpose.
And
I agree.
I ask, where does that get you?
And I agree.
So it doesn't address it, you've already submitted that that's addressed in a completely different part of the statute,
Yes.
which deals with liabilities
Yes.
and value. But what is it about section 49 that does anything that helps one way or the other than that it says what it says, which is the life interest, she's retained a beneficial life interest, and that's deemed to be part of her estate.
Well, that's my submission, my lady. That's it. But my first answer is I don't actually care if Section 49 doesn't authorise a deduction for liabilities incurred for no purpose other than tax avoidance, because it's not the provision I rely on in the first place to bring the trust liabilities into account. And precisely the same point applies to what is said in Section 39, paragraph 39.2.
I suppose, again, playing devil's advocate, Mr. Bradley, what might be said is, well, Section 49 treats the property as, treats her ownership of the property basically as being part of her estate. And if you give it a Rossendale/Ramsey approach, that means all of it. And if you enter into a scheme of this nature, Parliament's intention is that you then shouldn't take advantage of any provisions which might otherwise give rise to a deduction. In other words, the purposive construction of 49 is you get the property and the interest in the property, and that is what is liable to tax.
Well, yes, except that I think it's common ground that at least in some situations, you are meant to get a deduction for trust liabilities.
But not this one. That's the Rossendale gloss, I think.
Yes. Yes.
I think he's got to go that far.
Well, and then one has to ask why. I suppose the other way of putting it is that on the face of it, we only get to this issue if the revenue have already won on the debt incurred by issue. Because it's only if they're right about that these are actually the provisions which govern the bringing into account of trust liabilities.
Is that right?
Is that right?
I'm not sure that is right. I mean, I thought this was a freestanding point, which is if the revenue don't get home on 103 or 102, they say, well, you just look at Section 49 and Section 5
I think that's right.
themselves. I think that's right, isn't it, Mr. Davey? It is, yes.
I know that's what they say. The question arises, which provisions are you construing and what construction are you giving them?
Yes.
And the answer seems to be Section 49 and or Section 5 subsection 3 are the provisions which in general terms authorise a deduction, the bringing into account of trust liabilities. But they should be read as not authorising the bringing into account of a trust liability incurred for a sole tax avoidance purpose.
Yes.
But the first step in that argument has to be, these are the provisions
Which
that we're looking at in the first place.
and they're not, you say, because the word his in 5.3 relates to something different and it's all Section 164 anyway.
Yes, my lady. So I might be wrong about that, in which case this is an issue that arises, I suppose. And so I should say something about the construction of these provisions on the hypothesis that these are, one or both of these, are in fact the provisions that govern the bringing of trust liabilities into account. So, Section 49, subsection 1, as I've said a number of times now, provides that a person beneficially entitled to an interest in possession in settled property shall be treated for the purposes of this Act as beneficially entitled to the property in which the interest subsists. Now, how even assuming that that does implicitly deem the beneficiary to have incurred the trustee's liabilities, how, as a matter of construction of the words of section 49, subsection 1, do you get from that provision a kind of purpose, a sole purpose test? How? I can't understand what the answer to that is. It's just, insofar as the case is based on section 49, subsection 1, as a matter of construction, it's just hopeless. Section 5, subsection 3 is, on the face of it, slightly more promising because it does at least use the word liability. And at this point, it's important to be clear about what the revenue submission can and can't be. Because there would be a perfectly intelligible Ramsey-type argument along the lines of, when section 5, subsection 3 talks about a liability, it means a real liability, and does not therefore include a liability which, although it's not a sham, is never intended actually to be repaid by any of the parties to the scheme. Mm-hmm. And that is an argument which they ran in the FTT, but they failed to establish the factual premise of that argument, i.e., that none of the parties ever intended that the sum under the note should be repaid. So that can't be what they're saying now, because they've already lost on that in facts in the FTT. So what they have to be saying is that even though you've got a real liability, real in the Ramsey sense, you somehow construe section 5, subsection 3 as importing a sole purpose test, as providing that you do not bring a liability into account if, although it's real in the Ramsey sense, it has in fact been incurred for the sole purpose of tax avoidance. Now, there are, of course, a lot of provisions in tax legislation which impose a main purpose or a sole purpose or a wholly and exclusively purpose test. But they're usually set out expressly. And so the question is, how, as a matter of construction, do you say that there is an implicit sole purpose test in section 5, subsection 3? Please could we now turn to section 5, subsection 3 itself. It's at page 25 of the authorities bundle. And it provides, in determining the value of a person's estate at any time, his liabilities at that time shall be taken into account, except as otherwise provided by this Act. So, straight off the bat, the drafter of section 5, subsection 3 is telling you that if for some reason a liability isn't to be taken into account, I'll tell you about it somewhere else in this Act. And then we find an important example of a provision otherwise, in subsection 5, which says, except in the case of a liability imposed by law, a liability incurred by a transfer law shall be taken into account only to the extent that it was incurred for a consideration in money or money's worth. That's an important provision. You don't bring a liability into account unless it was incurred for full consideration. Section 103, which we've looked at already, then builds on that. It says on top of that, there are some liabilities which are incurred for full consideration, but it's the wrong type of consideration. Either it's property derived from the deceased, or it's consideration given by somebody who was at any time entitled to, etc., etc. So that is already doing quite a lot expressly. It's got to be incurred for full consideration. It's got to be the right type of consideration. And this statutory context, this is my submission really, makes it totally implausible that there is an unexpressed sole purpose test somewhere in there.
Sorry, which was the section you were saying is an example of the wrong type of consideration?
Section 103.
103, yes. Thank you. Yeah.
Because, of course, you only get to Section 103 if the liability has been incurred for full consideration.
Yes.
Otherwise, it's already knocked out by Section 5, subsection 5.
Well, I suppose the answer to that might be it's on the word liability. It's the interpretation of the word liability rather than purpose. So it's only certain types of liability that fall within 5.3 in the first place before you get to all those reservations. That's the way around that, I think.
Yes, but I mean, that is, I think, my learned friend's submission. But given that he can't any longer be saying liability means a, quote, real liability, he's lost that already. The substance of his submission is that liability means a liability not incurred for a sole tax avoidance purpose.
And then you come back into
the substance of that is to impose a purpose test of the kind that you do find elsewhere in the tax legislation, but to impose it by implication, despite the apparent scheme of the Act, to tell you expressly when you don't bring a liability into account.
Yes.
Then, just to continue in that vein, for the sake of completeness, Section 162, subsection 1, a liability in respect of which there is a right to reimbursement shall be taken into account only to the extent, if any, that reimbursement cannot reasonably be expected to be obtained. That is another provision expressly restricting deductions for liabilities. Over the page, on pages 40 to 42, you have sections 162A, 162AA, and 162B, which restrict deductions for liabilities attributable to financing excluded or relievable property. Now, for completeness, these 162A, AA, and B only came into force after Mrs. Elborne's death. But they are a continuation of the general theme, which is that if there's a reason you don't get to bring a liability into account, the drafter tells you about it expressly. So those are my submissions on why the provisions that my learned friend identifies cannot be construed in the way he says they can. Suppose I'm wrong about that, and that one of those provisions, on its true construction, should be read as not authorising a liability incurred for the sole purpose of tax avoidance. One then has to ask the question, well, in this case, was the liability under the note incurred for the sole purpose of tax avoidance? And that is a question of fact. Importantly, it's a question of fact on which HMRC bore the burden of proof. That's paragraph 31 of the FTT's decision, page 233 of the core bundle. And that has not been disputed. On this issue, this, whatever we're calling it, Rossendale Section 49 issue, HMRC bore the burden of proof.
Is that because it was not a point specifically taken in the closure notice, or whatever it's called?
That's right. It's because it wasn't a point included in the notice of determination. Therefore, it was HMRC who were asking the tribunal to vary the notice of determination, and accordingly it's them who bear the burden of proof. So the place to start is, given that HMRC bore the burden of proof, what was actually pleaded? Their amended statement of case is at, I'll have to find the tab, sorry, but it's at page 281 of the supplementary bundle, which is tab 32. Importantly, this is not the original statement of case. As indicated in the heading, this is the amended statement of case, amended pursuant to the order of Judge Beer, dated 12th of May 2023, i.e. a week or two before the FTT hearing itself. This is the first time this issue is introduced at all. And what is said about it, for that we have to turn to paragraph 69 on page 297 of the bundle. Rather confusingly, it's under the heading Reservation of Benefit in the Property. I can't remember why that was, but that is the place they decided to insert this amendment. And what does it say? As set out above, HMRC will invite the tribunal to find that the note, on a realistic view of the facts, did not constitute a liability of the trustees of the Trust 1, on the basis that neither Mrs Elborne or the trustees of either trust intended the note to be repaid. Well, that point's gone now. Yes. And in any event, the note did not fall due until Mrs Elborne died. Well, that's common ground. Accordingly, even if the property was, contrary to HMRC's submissions above, transferred by Mrs Elborne to the trustees of Trust 1, no deduction can be made in respect of the note under Section 49, subsection 1 of the 1984 Act, either because it was not a liability at all, again, that point's gone, or because even if it was a liability, the note is not part of the property in which Mrs Elborne had an interest in possession. Section 49(1) operates to treat Mrs Elborne as beneficially entitled to the whole of the value of the property, not reduced by the value of the note, because the tax avoidance arrangements create a life interest and corresponding debt as part of the same scheme on terms where it is never intended that Mrs Elborne's interest and enjoyment of the property will be disturbed during her lifetime. Viewing the effect of these arrangements realistically, her interest does not subsist in the trust fund net of the note, as the note is explicitly postponed to her interest. Thus, Mrs Elborne's enjoyment for life of the trust fund was not impinged upon by the liability. Consequently, the full value of the property falls to be included in Mrs Elborne's estate under Section 49(1) of the 1984 Act.
That's a somewhat different argument, isn't it?
It is, my lady, to the extent I understand it at all. But
well,
more
it's
important,
saying that because the liability doesn't in any way affect the nature, value, or quality of her beneficial interest, you look at the whole of the beneficial interest, which is brought into account under Section 49(1), and you ignore it completely, I think.
So it's not a liability at all?
It's not a liability at all, or not a relevant liability. Which is somewhat different from saying
yes,
that the liability is her liability is the same as the trustee's liability, and you bring it in under 5(3).
that argument was made and addressed in the FTT, but the point for present purposes is this is it. I'm not exaggerating, this is it. This is, if one's looking for a basis in the pleadings for what is now the Section 49 Rossendale statutory construction argument, this is all there is. And on any view, there is no allegation here that the liability under the note was incurred for no purpose other than tax avoidance.
Is 74 some?
This is about disposal by way of gift.
Yeah.
74. I mean, this is what this is the point Miss Belgrano was making this morning, i.e., she sold the property and gave away the proceeds, and somehow Ramsey tells you that's a gift of the property. That's the point.
Sorry.
Yes, it's under 102 and 101, 102(1) A and B arguments. Which is part of the alternative case to what's pleaded in section 60, in paragraph 69.
Mm-hmm.
It's a little bit difficult because this version doesn't show which bits are amendments and which bits are original. And the point in question is inserted under the heading of reservation of benefit in the property, despite not really being a point about that. But the relevant amendment was the one in paragraph 69. So the point I'm making is this wasn't even a competent submission in the FTT. A fortiori, it's not open to my learned friends to make that factual submission in a second appeal on a point of law. So how do they get around this? Well, they say, okay, you didn't have a chance to get evidence from the surviving life trustee as to his subjective purposes in incurring the debt, but someone who did give evidence is Mr. Mark Elborne, and the FTT found that he said that the purpose of the scheme as a whole was to save inheritance tax. That isn't good enough because as the court explained in BlackRock, if you are considering a statutory provision which directs you to ascertain the purpose for which something was done, that requires you to ascertain the subjective purposes of the relevant actor. In this case, the life trustees. Now, my learned friend said, I didn't quote the words in brackets, save in obvious cases. This is an obvious case. You don't get to say, this is an obvious case, if you have failed properly to plead any case at all. And even if we just take the facts found by the FTT and ask ourselves what inferences we can draw from them, I'm not saying that's permissible, but let's assume it is for a moment. It's not an obvious case, because on the face of it, as my Lady Justice Andrews pointed out yesterday, at least one apparent purpose of the life trustees in issuing the note was to acquire the property, which, after all, they acquired at a substantial undervalue. Now, you could, of course, argue that subjectively they didn't care about acquiring the property, they only cared about playing their part in the scheme. You could argue that, but that would be an argument of fact which would have to be made in the first-tier tribunal on the basis of appropriate pleadings and evidence.
Sorry, I may have misunderstood something, but did I understand you to say that there was some reason why the other life trustee couldn't give evidence, the solicitor?
No, there was no reason Mr. Wolfe could not have given evidence.
That's what I thought. I thought
he could have.
There was some such reason.
No, there was no reason.
Yeah.
He could very well, as far as I know, have given evidence, had we been aware that there was a reason for him to give evidence.
Yes.
What you're saying is it should have been pleaded, and then he might have actually called him so that he could say what his subjective views were.
That's my point, my lady, yes. And then finally, if I'm still wrong about everything, so that it's permissible to base this whole aspect of the case on Mr. Mark Elborne's evidence, it might help to look at what he actually said in cross-examination. That was the basis for the FTT's finding. This is in the cross-examination, the transcript of the cross-examination is in tab 33 of the supplementary bundle. And the relevant part comes at page 322. This is in the middle of a long series of questions from my learned friend aimed at the issue, were you ever actually going to demand repayment of this note?
And Mr. Mark Elborne was a trustee of the family trust?
Was a trustee of the family trust, so was an appropriate person to give evidence about whether the family trustees actually ever intended to demand repayment. This is what he was actually giving evidence about. But anyway, within that, within the internal transcript numbering page 73, the second question on page 73, and that, i.e. the fact that you didn't register a caution, reflects the fact that the purpose of the promissory note was an element within the scheme to reduce the IHT estate. I mean, that's the purpose of it, isn't it? Answer: that was the purpose of the arrangement, was so that the promissory note was gifted to us as trustees more than 7 years before my mother died. We didn't know when she was going to die, but that was the arrangement. Question: there is no sort of commercial business angle on this, is there? Answer: I don't understand what you mean by commercial business angle. Question: any non-inheritance tax angle? Answer: no, there was no non-inheritance tax angle. So if contrary to everything I've said, the Revenue are allowed to base their factual case on what Mr. Mark Elborne said in evidence, what did he say? Well, what he said, what he identified as the purpose, was very similar to what Lord Justice Millett identified as the purpose of the transactions in Ingram. The purpose was for Mrs. Elborne to make a gift of the note and hopefully survive 7 years from it. Would she have done this if inheritance tax didn't exist? No, of course she wouldn't, but who cares? That, finally, is all I have to say on Ramsey. So unless there are any particular questions on that issue, I'll move on to reservation of benefit in the note.
Thank you.
And I'll start, as my learned friend did, with the second limb of section 102(1)(b). So we're going backwards in a sense, but there's not very much to say about 102(1)(a or the first limb of 102(1)(b). It is common ground that Mrs. Elborne's occupation of the property, pursuant to her life interest under the life settlement, was a benefit. It is also common ground that that benefit arose by virtue of operations associated with her gift of the note. And the Revenue's case, as I understand it, is that is enough. That is a radical submission for 2 reasons. First of all, it makes the second limb of section 102(1)b almost absurdly broad. My learned friend took you yesterday to the definition of associated operations in section 268. And the court will, I hope, recall that the definition of associated operations is extremely broad, and accordingly that it is extremely easy for operations to be associated with one another, so that if all that's required for the application of the second limb of section 102(1)b is that you can find a benefit somewhere and link it by some chain of associated operations back to the disposal by way of gift. There is a huge amount of stuff that is going to be caught. So that is the first reason why it's a radical submission. The second reason is that it ignores about a century's worth of binding authority, because it is established by authority that it's not enough that you can find a benefit somewhere that has some kind of causal connection to the gift. And there are two principles established in the cases, and critically established as a function of construction of section 102(1)b. Not established as indicia that might be helpful in some cases and not in others. The first is that for a benefit to the donor to be within the second limb of section 102(1)b, it has to be a benefit which arises from the property given, not a benefit which arises from property which the donor has kept. That is what's sometimes described as referability. The label doesn't matter, the underlying principle does. The second principle established by the cases is that even if a benefit does arise from the gifted property, even if it cannot be said to be referable to property which the donor has retained, it is nevertheless still not within the second limb of section 102(1)b, unless it, the benefit, has some detrimental impact on the donee's enjoyment of the gifted property. That is sometimes called trenching. Again, the label doesn't matter, the principle does.
Detrimental impact on the enjoyment of the...
On the donee's enjoyment of the gifted property.
And is the gifted property we're looking at here the loan note?
Yes, my lady.
Yes.
And I think that's common ground.
Yes, yes. Just getting my head around it, yes.
So we will now have to look at the relevant cases, starting with the House of Lords in Ingram. I'm sorry, I should have said, first of all, how those principles apply to the facts of this case. Referability. What was the benefit? The benefit was Mrs. Elborne's occupation of the property pursuant to her life interest under the life settlement. That, in my submission, was plainly referable to the property she kept, i.e. the house, not to the property she gave away, the note. And this is the real oddity of the Revenue's case on this point, that they're trying to attack the gift of the note by reference to a benefit she got from the property. It doesn't make sense, and the case is established that it doesn't make sense. Even if I'm somehow wrong about that, did Mrs. Elborne's occupation of the property have any impact at all, beyond a de minimis impact, on the donee's enjoyment of their rights under the note? And the answer to that, again, is obviously no. The note consisted in the right to repayment of a sum of money after Mrs. Elborne's death.
And that's inherent in the note itself.
Yes.
What's been said is, well, they couldn't get repayment until she died, but that's what the note itself provides.
That is the property she gave.
Yes.
And that's,
yes.
Yes. And that's what both tribunals below found, and I submit they were right to do so. All right, sorry. The cases. Ingram is at tab 28, page 416. I think I've already said what the facts were. So we can please go to page 422 of the bundle. In the speech of Lord Hoffman. And just by the letter H, there's a paragraph starting, section 102 has a long history. Provisions in similar terms existed in connection with estate duty and before that account duty. There have been similar provisions in Australia. It has been interpreted on a number of occasions by the House of Lords and Privy Council. The theme which runs through all the cases is that although the section does not allow a donor to have his cake and eat it, there is nothing to stop him from carefully dividing up the cake, eating part, and having the rest. If the benefits which the donor continues to enjoy are by virtue of property which was never comprised in the gift, he has not reserved any benefit out of the property of which he disposed. See St. Aubin. That is what I mean by referable. Then at page 427, there is, by the letter D, there's a paragraph beginning before parting with this aspect of the case. And what follows from there and then over the page until letter C on the next page is an authoritative statement of the policy of section 102. And it's cited in every subsequent case, but it is in my submission very important So, with apologies to those members of the court who have read this before, please may I invite your ladyships and your lordship to read the sidebarred passage.
This is the one at 427 to 428.
That's right, my lord. Yes, please.
There's a certain familiarity about the arguments that Lord Hoffman is dealing with there, isn't there, between E and F? It's very similar to the case that you're having to meet.
It certainly rings a bell, my lady.
Sense, it must be contrary to policy
Yes.
and statute to be able to give away the property.
And here the court was concerned with a freehold reversion,
That's right.
having been separated out from
Yes.
a leasehold interest.
Yes.
Here we've got you transfer the freehold to the life trustees, and you are granted a life interest. So then you have a life interest. The note is in respect of the freehold, is the consideration
Yes.
for the freehold. So Lord Hoffman is saying Section 102 is concerned with interests.
Yes.
In that regard, how does that work with the
Yes,
note?
that
Just so that
part
we're
is-
certain.
That part of what Lord Hoffman says is not as relevant to this case because we are not dealing with different legal interests
No.
in the same physical thing.
No.
The relevant points in this passage are, first of all, what is the policy?
Yeah.
Is it about cakes and eating it and too good to be true and common sense and so on? No. The policy is you have to be clear about what you're giving away and what you're keeping. And my learned friend said, well, all of these cases are about different types of property right in the same land. And it's true, they are, and Ingram was. But all that means is that we're a fortiori of Ingram, because in this case, there can't be any doubt about what Mrs. Elborne gave away, i.e. the note, and what she kept, i.e. the house. In Ingram, there was at least potential for confusion, because we were talking about different legal interests in the same thing. There isn't even that element in our case. So that's the first point. What's the policy? The second point is what is the relevant rule? And here on page 428 of the authorities bundle, in between B and C, Lord Hoffman says, it laid down a rule that if the donor continued to derive any benefit from the property in which an interest had been given, it would be treated as a pretended gift unless the benefit could be shown to be referable to a specific proprietary interest which he had retained. Again, that is the principle of referability.
She herself has no benefit from the loan note at all.
No.
And certainly her staying in the house has got no reference to the loan note. It's a separate thing. It was granted independently by the trustees of the settlement.
Well, she's staying in the house either because of the trustees' resolution or because she's the only person entitled to an interest in possession in the first place. But both of those are... That's not the thing she gave away.
No.
Now, at this point, I'm debating with myself whether to refer your ladyships and your lordship to another half a dozen cases saying exactly the same thing. I'd rather not do that. May I instead please just refer to Lord Justice Millett in the Court of Appeal and my Lord Sir Launcelot in Hood, because just to make the point that this principle of referability is a function of construction. It's not an indicium. The Court of Appeal in Ingram is tab 26. And the relevant part of Lord Justice Millett's judgment starts at page 380. Just by the letter D, he cites the provision.
I'm so sorry, I've just lost my terms in the model. Where are we looking?
So this is, we're in tab 26.
Tab 26.
And
Page 380.
it's page 380 of the bundle.
Yep. Yes.
And by the little letter D, there's a citation of section 102(1)(b). or its predecessor provisions. And then Lord Justice Millett says, the grammatical structure of these provisions indicated that the property in question was the property given, and accordingly, adopting a somewhat literal construction of the statute to the possible detriment of its evident legislative purpose, the courts laid down a settled rule that it was only the possession and enjoyment of the actual property given from which the donor must be excluded. It was therefore necessary in every case to identify with precision the interest which formed the subject matter of the gift. If the donor was not excluded from possession and enjoyment of the very interest which he had given, then relief from estate duty was denied. But relief from estate duty was not denied merely because the donor continued in possession and enjoyment of some other interest in the same property which he had not given. Again, we're a fortiori of that. It's not even some other interest in the same property. It's some other interest in different property. Then there's a quote from Lord Radcliffe in St Aubyn. Then Lord Justice Millett goes on, the distinction between a gift of the whole property with a gift back of a limited interest in the property on the one hand, and a gift of a limited interest only in the property, the donor retaining what he has not given on the other, is not always easy to draw. The distinction is an artificial one, which depends on form rather than substance. It was trenchantly criticised by Lord Radcliffe in St Aubyn, where he deplored the fact that when Parliament had found the time in 1940 to repeal and reenact the legislation concerning gifts with reservation of benefit, it had not taken the opportunity to make it intelligible. The replacement of estate duty by capital transfer tax made it unnecessary to retain the provisions which dealt with gifts with reservation of benefit, and they were duly repealed. The replacement of capital transfer tax, in turn, by inheritance tax in 1986, however, made it necessary once more to deal with the problems caused by such gifts. Parliament did so by Section 102 of the Finance Act 1986. Despite the criticisms which had been levelled at the earlier legislation, it reenacted it almost verbatim. It thereby revived the artificial distinction between a gift where the donor remains in possession and enjoyment of the subject matter of the gift, and a gift where he remains in possession and enjoyment of some other interest in the same property which is excluded from the gift. Given that in either case the donor's purpose is to obtain a tax advantage, and that in either case he may be with equal justification, I suppose it should be, the first B shouldn't be there, be said to eat his cake and have it, Parliament must be taken to have considered the one course of action but not the other, to be what Lord Scarman described as the safe channel of acceptable tax avoidance, see Furness and Dawson. The difference between acceptable and unacceptable tax avoidance is preeminently a matter for the legislature. If Parliament has drawn the line in a particular place, however incongruously, it is not for the courts to draw it elsewhere. That is Lord Justice Millett summarising the previous case law in Ingram, and then there's my Lord Sir Launcelot in Hood, which is tab 40. Page 710. And the relevant passage starts at page 716. This is at the beginning of the magisterial summary. And at paragraph 16, my Lord says, I have already set out the gift with reservation provisions in section 102, which govern the present case, but this is an area of tax law where the historical context of the legislation is of central importance. far from representing a new set of provisions drafted from scratch or building upon the conceptual framework of capital transfer tax, which had been introduced by Part 3 of the Finance Act 1975 and consolidated in the Capital Transfer Tax Act 1984, the gift with reservation provisions were deliberately based on materially similar legislation which had formed part of the law of estate duty from its introduction in the Finance Act 1894 until its eventual repeal upon the introduction of CTT. Indeed, the critical wording with which we are now concerned may be traced back still further to the charge to duty on accounts of a person's property after his death imposed by Section 38 of the Customs and Inland Revenue Act 1881, as amended by Section 11.1 of the Customs and Inland Revenue Act 1889, which extended the charge so as to embrace, then there's a quote, paragraph 17, these and similar provisions, both in the United Kingdom and in other jurisdictions within the British Empire or Commonwealth, proved far from easy to construe or apply. During the period of 80 or more years when they formed part of the estate duty legislation, they generated a considerable volume of case law, including several leading cases in the House of Lords and Privy Council. The enactment of Section 102 therefore carried with it a considerable freight of prior jurisprudence on a notoriously difficult topic, which many people probably hoped had been consigned to oblivion when the estate duty legislation was repealed in 1975. My Lord Sir Launcelot is there saying something quite similar to what Lord Justice Millett said in England. A considerable freight of prior jurisprudence on a notoriously difficult topic. But that doesn't sound like we're talking about an area of tax law where it's all a question of fact for the special commissioners. Again, my point is that the principles I'm talking about are principles in the true sense. They're a function of construction of Section 102(1)(b). That is the principle which I'm calling referability, on which, as I said, one can find a dozen cases saying the same thing. Trenching, I accept, is different in that I am really only relying on one case. That isn't a problem for me, because the case in question is a decision of the Court of Appeal, the ratio of which was that the benefit was not within the second limb of 102(1)(b) because it did not impact on the donee's enjoyment of the gifted property, and therefore, with respect, it's binding. But it is only one case, and that case is Bozzoni, which is at tab 37, page 651 of the Authorities Bundle. The arrangements in Bozzoni, and indeed in Hood, involved the grant by the donor of a reversionary lease of property which she occupied as her main residence. The basis of the planning being that while the lease remained in reversion, the donor's occupation of the property was referable to the freehold interest she retained. It's like Ingram, but the other way round. The problem in both Bozzoni and Hood was that the donor's property was itself a leasehold interest. And therefore the sublessees, i.e. the donees of the reversionary lease, had to enter into covenants to observe the covenants in the head lease. And on the following an earlier decision of the Court, a state duty decision of the Court of Appeal in a case called Nichols, those covenants were, at least arguably, well, not arguably now definitely, a benefit reserved out of the property given, rather than an incident of the freehold which had been retained. In Bisoni, the sublessees, pursuant to a license to underlet granted by the head landlord, had covenanted directly with the head landlord to perform the covenants in the head lease before the donor granted the reversionary sublease to them. And it's that fact, and that fact alone, that made all the difference between Bisoni and Hood. Please could we start at paragraph 15 in Lord Justice Moses's judgment, that is page 656. Where Lord Justice Moses says that section 102(1)b has two limbs, he goes on to say it's not clear whether, from the decisions below, whether the revenue were relying on both of them, but the revenue specifically accepted in the Court of Appeal that it relied only on the second limb. Its essential submission was that the positive covenants in the underlease constituted a benefit taken by the deceased back from the property she gave, and that, therefore, the donees did not enjoy the underlease to the exclusion of a benefit to the donor. The revenue submitted that that was the only issue. The court had to decide the source of the positive covenants from which the deceased benefited. Did she receive them back from the underlease of which she disposed, or were they benefits enjoyed by virtue of her reversionary interest in the head lease, which was never comprised in the gift? That is the issue which I have been calling referability. The submission of the revenue is that is the only issue. The taxpayers denied that that was the only issue. They contended that even if, contrary to their submission, the source of the positive covenants was the underlease, the benefit the deceased received was not a benefit within section 102(1)b of the Act, because it was not a benefit at the expense of the donee's enjoyment of the underlease. Then paragraphs 17 to 29 concern the referability question, which Lord Justice Moses decides in the revenue's favour. That is to say, he holds that the benefit of the covenants was something reserved out of the gifted lease rather than retained with the intermediate lease. And if the revenue were right that that was the only issue, that would necessarily have been the end of the case. But it wasn't. Paragraph 30, the revenues say that conclusion is dispositive. Once it is concluded that the benefit was derived from the gift, That, they say, is the end of the inquiry. Not so, say the taxpayers. This second limb of the subsection focuses on enjoyment by the donee of the gifted property, not enjoyment by the donor of the benefit. The question, so the taxpayers submit, turns on whether the donee's enjoyment is to any, save a minimal extent, impaired or reduced. If the impugned benefit makes no difference to the enjoyment of the property in question, then it cannot, so the argument runs, be said that it has ceased to be exclusive.
And since they were already under the obligations to the head landlord, it made no difference. That was the argument.
That's the basis on which the taxpayers won.
Yeah. And in Hood it was different because the obligations are only undertaken as part and parcel of the gift.
That's right, my lord. But,
and it was a very fine distinction.
Yes. But that is... that's my submission, really. This is the area of law we're dealing with.
Yes.
Paragraphs 30 to 48 consider all of the previous authorities which are said by the taxpayers to support the existence of a trenching requirement. And Lord Justice Moses's conclusion as far as the authorities go is at paragraph 49 on page 666. Where he says in summary that the authorities he's been referred to do not in fact establish in and of themselves that there is a trenching requirement. He goes on then, however, to say at paragraph 50, it seems to me that there is sufficient support for the taxpayer's contention to be found in the wording of the subsection. The second limb of section 102(1)(b) of the 1986 Act requires consideration of whether the donee's enjoyment of the property gifted is to the exclusion of any benefit to the donor. The focus is not primarily on the question whether the donor has obtained a benefit from the gifted property, but whether the donee's enjoyment of that property remains exclusive. The statutory question is whether the donee enjoyed the property to the entire exclusion, or virtually to the entire exclusion, of any benefit to the donor. If the benefit to the donor does not have any impact on the donee's enjoyment, in my view, then the donee's enjoyment is to the entire exclusion of any benefit to the donor. So again, this is construction of the statutory wording, explicitly so. And this is the ratio of the court's decision because the taxpayers had nothing else going for them. This is the only explanation of why they won. Then we see at page 668 of the bundle, both Lady Justice Black and Lady Justice Gloucester agree with Lord Justice Moses that the appeal should be allowed for the reasons commencing at paragraph 30 of his judgment. I.e. the part about trenching. So that is, in my submission, plainly the ratio of the Court of Appeal in Bisoni. It is therefore binding on this court. The benefit to Mrs Elborne in the form of her occupation of the property, even if it was somehow referable to her gift of the note, which it wasn't, cannot be within the second limb of section 102(1)b unless it had some detrimental impact on the donee's enjoyment of the note. And in my submission, it plainly didn't. Now, my learned friend did say, even if he's wrong, and there is a trenching requirement, he says it was nevertheless satisfied on the facts here. Now, as a preliminary point, if it is established as a matter of law that it is necessary for the benefit to negatively impact upon the donee's enjoyment, then the question for the court, the question for the court or tribunal is, did it in fact, this benefit, did it in fact negatively impact upon the donee's enjoyment? And that is the kind of question that one would have thought would be a question of fact for the first tier tribunal, which did find, on the facts of this case, that the benefit in question had no impact on the donee's enjoyment. My learned friend hasn't even attempted to submit that that conclusion was outside the range of reasonable conclusions the FTT could have reached on the evidence in an Edwards and Bairstow sense. It was plainly reasonable, and indeed it was plainly right. Just in case I'm wrong about that as a matter of overall approach, I should address the 2 points my learned friend made about why the benefit did trench. I can see the time. Would it be all right if I just address those points now?
I think that's sensible.
So the first point he made was about the provision in condition 4 of the note for events of default. And if I understand his point correctly, what he was saying is that if an event of default actually happened during Mrs. Elborne's lifetime, practically speaking, the trustees of the family settlement, being as a matter of fact Mrs. Elborne's children, would impede their own enjoyment of the rights under the note, i.e. would not exercise their rights in an event of default because their mother was living in the property, their parents were living in the property. That is what I understood the submission to be. But that, again, is a question of fact.
It also ignores the express provisions of the note that you can't enforce it until after she dies. I mean, the events of default are very particular. You've got to drill down into what they are.
Yes. Well, the first point I make is that's a question of fact. That certainly is something Mr. Mark Elborne, as a trustee of the family settlement, could have been cross-examined on. He wasn't. So it's not open to my learned friend to make that submission now. But also, I'm not even sure the submission makes sense on its own terms, because as far as I can tell, the purpose of Condition 4 is rather the same as the purpose of any default event clause in a loan instrument, i.e. to accelerate the liability falling due in the event of the debtor's insolvency or situations akin to insolvency. And so in other words, if one of the events in Condition 4.2 to 4.5 actually happened, the consequence of the family trustees not exercising their rights, on the face of it, would not have been that their parents would have gone on happily living in the property. It's that somebody else would have been able to resort to the property for payment of their debts. So actually, if an event of default had actually occurred, why wouldn't they?
Can we actually look at the loan note again? Do you mind? Where do we find it?
Sorry.
I think it's in the supplement. Oh,
Yes. What?
Tab 5. Just so we're not looking at this in a vacuum.
Yes.
Right, so let's look at the events of default. 4.1, trustees fail to pay any sum when due. Well, not due until after she dies. Or are in breach of any provision of this note. Right, well, that depends on the only provision, I think, is repayment, which is once it's called on after demand, so same point. Any distress or execution is levied on the whole or part of the trust assets, which is not discharged or paid within 21 days. Well, who's going to do that except a third party?
Yeah.
And once it's a third party, you're outside the family wall. The trust is at any time revoked or set aside or held to be invalid or void. Well, what do you say about that?
On the face of it, it's hard to see how it could have been revoked because the settlement wasn't revocable, or indeed how it could have been set aside. But I suppose that those are situations. I suppose the logic of this
they're no longer a trustee.
Is where they no longer have the trust assets they thought they had to resort to. They're just people who are personally liable for this debt.
Are to default under any other financial obligation to any person arising in connection with the trust. Difficult to see how that arises. And then there's the occurrence of the events to sell the property, which is a point that was taken against you. Is that if you look at paragraph 4, the whole purpose of paragraph 4 is that the reality is that they're supposed to sell the property. And it said, well, they wouldn't sell the property because the parents are living in it.
Yes, to which I say, number one, this is a question of fact. Mr. Mark Elborne was not cross-examined on it. But number two, actually, if any of these things happened, why wouldn't you sell the property and pay off the loan note?
Well, I think that was the point.
The alternative does not appear to be that Mr. and Mrs. Elborne Sr. get to go on happily living in the property.
Well, why would the trustees find themselves in a situation where the very source of the finance to be able to discharge the obligation is taken away from them? Doesn't make much sense to me. If the alternative to selling the property is that they go bankrupt.
Yes, and of course Mrs. Elborne herself was one of the trustees.
Yes. Right.
Anyway, that was the first of my learned friend's reasons why there was actual trenching, as it were. The second, however he dresses it up, amounts to saying that the loan note was not repayable until after Mrs. Elborne's death.
Yeah.
You know, you can say it was sculpted to her advantage as part of a pre-planned scheme, if you like, but that's just a different way of saying the same thing.
Yeah.
It wasn't repayable until after her death, but so what? That was the property given. And you could say she did that on purpose. She deliberately chose to give away a debt that wasn't repayable until after her death. In the same way that Lady Ingram deliberately chose not to give the trustees the whole house, but to give them only the freehold reversion. But again, so what?
Well, her enjoyment of the property has nothing to do with that.
No, well, I agree with that, my lady. But the point I'm addressing now is that there is
no trenching.
There is somehow actual trenching because the thing the donees were given wouldn't bear fruit until some point in the future, until after Mrs. Elborne's death. And all I say is, so what? I haven't dealt with 102.1a or the first limb of 102.1b. I don't think there's anything I really need to say on those, apart from that I endorse the reasoning of both tribunals below. If I do think of something I need to say, would it be all right if I say it tomorrow morning before I go on to reservation of benefit in the property?
Certainly.
I'm very grateful.
Thank you. On that basis, you're likely to begin with ground. Well, we're right on to 102 property.
That's right, my lady.
Yeah. Thank you very much indeed. 10:30.
Court rise at table.